from the daily court list at 2:50 and waiting for hearing item 1 WPC 3320 along with item 2.
Why are there two cases? Why two cases?
Two proceedings. One was initially two pieces of land. One bought in the name of the husband, one bought in the name of the wife. The wife has passed away, the husband has been substituted.
Which case?
332 murders.
332.
I have noticed two basic points. One is limitation, and two is that the nature of the land has changed from regulated to suburban. So far as limitation is concerned, my point is that none of the courts, authorities, have given any finding regarding the date of disposition, manner of disposition, which is required. It appears that in the application,
Just a minute. Limitation has been dealt with.
limitation has been dealt with in the reverse manner, saying that I have not been able to show a registered deed of surrender and henceforth the hukumnama is not acceptable. Therefore, please, otherwise there is no limitation which has been dealt with from their perspective. Their case was that from 76 to 80 in the original application, the mental health of the applicant was not right. Somewhere between 76 to 80 we disposes. So that also had to be proved. There could not have been any oral evidence, documentary evidence, but there was no oral evidence there. So only on the basis of an assertion made that from 76 to 80, I have been dispossessed, this application has been allowed. In the counter affidavit, they took a plea that I have been dispossessed in 81, 82. But I am not going by the counter affidavit, because counter affidavit is immaterial today. But this only shows the inconsistency of this. The first point is that it is for the applicant to assert and prove the date of disposition. It goes to the root or jurisdiction of the matter. I am not have a judgment rendered by your Lordship in this point. In the CMT Act, which is the first judgment on that compilation. Now, so far as
their original application is on record.
No, that is not. That we have not been able to file, neither they have been able to file.
From where do I get this?
Yes. Kindly come here.
The first order.
The SAR appeal. This was actually the appeal was in fact sent back to consider the point of Chaparbandi, but let us, after the first remand.
Where is the first order?
The first order is before the remand.
Yes.
I don't think the first order will be set aside. Is in Annexure 6 is the appeal order. If you also kindly comes to the appeal order.
Annexure 6.
Order of Annexure 6, order of remand.
Yes.
This appeal is an appeal filed against the order dated 29/9/1985 passed by Sri So-and-so, Special Officer in SAR case number so-and-so. The short history of the case is that the present respondent so-and-so filed application in the lower court on 24/6/1983 against the present appellants J.P. Verma, his wife Urmila Verma, C.H. Srivastava, his wife so-and-so, and Dr. H.P. Narayan. We are concerned with this only for restoration of the land bearing khata number so-and-so, situated in Moja so-and-so within Rachi town, on the ground that the same is an illegal occupation of the OP members in the lower court and has got transferred fraudulently. Accordingly, SAR case number 62/83/84 was started in the lower court. When on consideration of the respective claims of the parties concerned, it has been ordered on 29/9/1986, the land in question be restored to the petitioner in the lower court. Respondent in this appeal. The present appeal has been preferred against the order of the lower court. The case of the applicants is that the land in question is Chaparabandi, and therefore Section 71A of the CLT Act is not attracted. In the case, several papers and documents have been filed in support of this contention, and 3 witnesses have also been examined in the lower court. On behalf of the present respondent, no witness was examined in the lower court. The lower court has also not discussed the evidence of the witnesses examined by the applicant in the lower court. Thirdly, according to the appellants, after the argument was done on 7/8/86 without notice to the appellant or their advocate, Vaidnath Rao was inducted as a party and a medical certificate by one of the OPs was filed on 2/9/1986. It appears from the judgments that Vaidnath Rao is now not mad. Lastly, it has been contended on behalf of the appellant that no reasonable opportunity was given to the appellants. Besides, the medical certificate has not been given by the civil surgeon or the authorized doctor or superintendent of Kapi Middle Hospital. The lower court has restored the land to the wife of Vaidnath Rao, although according to the Rao custom, female cannot acquire any land. Therefore, the order of the lower court is illegal. The restoration petition is also barred by limitation, as it has been filed after expiry of 30 years. The case of the respondent, on the other hand, is the land in question is not Chaparbandi. It has been recorded in the Khatyan in the name of Adivasis. It was purchased by one Harihar Rao, father of Vaidnath Rao. The present respondent, Kirito, is the wife of Vaidnath Rao in the year 1940 by registered sale deed number 4786. In that year, the permission of Deputy Commissioner was not required in the transfer of land by one member of the scheduled tribe to another member of the scheduled tribe. The land in question was never converted to Chaparbandi either by the Khatyani Raiyat or by the purchaser. Therefore, transfer of the land in favor of the appellant is illegal. According to the respondent, the area of 0.2 acres was acquired in RMCH, for which compensation was paid to Harihar Rao. Besides, Suprema Rao, wife of Harihar Rao, and her son Vaidnath Rao have also sold other plots of Khata number 77 after obtaining permission from the rent suit deputy collector under section 46 of the CMT Act, white case number. I have heard the learned lawyer on behalf of both the parties. I have gone through their argument. I have also run through the lower court records and the order passed therein, and also papers and documents in the record. From perusal of the Khatyan certified copy available in the lower court records, it appears the land in question, Khata number 77, case number so and so, area 1.2 acres, stands recorded in the names of Babra Rao, son of Purayo Rao, and that Bundi, wife of Saiya Rao, jointly having equal shares. Harihar Rao, father of Vaidnath Rao. Vaidnath Rao is the husband of the present respondent, Srimati K. Topo, purchased along with other plots from Bhama Rao by registered sale deed number 4786 in the year 1940. Therefore, the present respondent or her husband, Vaidnath Rao, in whose favor the land in question has been restored, are not the Khatyani Raiyats of the land in question. It was claimed the father of Vaidnath Rao purchased it in the year 1940 from one of the Khatyani Raiyats, that is Baba Rao, and the other co-sharer, most he was dead. The petition for restoration has been filed in 1983 by wife of Vaidnath Rao because Vaidnath Rao was of unsound mind at the time. However, it appears from the perusal of the lower court's order that later on Vaidnath Rao became alright and a certificate to the second was also filed. However, the lower court has restored the land jointly to Vaidnath Rao and his wife, Kirito. Appellant's main contention on 1. Land in question is Chakrabandi, in support of which several documents were filed in the lower court but was not considered. No witness has been examined on behalf of the applicant. Now I find that the evidence have not been dealt with carefully. It is not disputed that if land is Chakrabandi, no proceeding on 71 of same date can be initiated for the restoration of the land. The lower court has discarded the claim of Chakrabandi rather summarily. For the ends of justice, it seems that necessary that the claim of Chakrabandi character of the land should be examined minutely after giving opportunities to both the parties to produce evidence, both oral and documentary. In the present case, no witness has been examined by the respondent in the lower court. Therefore, the reasoning given by the lower court in a cursory manner and the claim of Chakrabandi is not acceptable, does not come to the ends of justice. For the proper adjudication of the case, and particularly when Vaidnath Rao, who is a normal state of mind, the case is remanded back to the lower court for fresh examination in light of the observations of all. In the result, the appeal is allowed and the lower court's order is set aside. This was not challenged by anyone. Thereafter, the matter of remand in the Annexure 7 was passed. The next. May I please put 1397 the order is passed. दिनांक 29/8/19 में अंतिम आदेश पारित आवेदक के पक्ष में दखल देने का आदेश दिया गया था, जिसके विरुद्ध विपक्षियों द्वारा अपर समर्था रांची के न्यायालय में सेकंड अपील वाद संख्या 131 R 1586/87 दायर किया गया। भारत SAR अपर समर्था ने अपने आदेश दिनांक 26/12/91 द्वारा वाद को पुनः सुनवाई हेतु वर्तमान न्यायालय में लिया गया था। माननीय अपर समर्था रांची के दोनों पक्षों को अपना पक्ष स्थापित करने के लिए उचित अवसर देकर सुनवाई करने का आदेश दिया गया था। माननीय अपर समर्था के आदेश के आलोक में दोनों पक्षों को पूर्ण नोटिस निर्गत किया गया। वो उसमें उपस्थित होकर अपना साक्ष्य प्रस्तुत किए हैं और सुनवाई के दौरान मालूम और द्वारा 22/8/2000 को उसमें एक आवेदन देकर आपत्तिकर्ता आवेदन का अनुरोध किया गया है। आपत्तिकर्ता के आवेदन पर पूरा आवेदक द्वारा प्रतिशतों पर दायर किया गया है और आपत्तिकर्ता आवेदन दिनांक 4/11/84 लिखादर्ज कर दिया गया और उसके विरुद्ध आपत्तिकर्ता द्वारा माननीय अपर समर्था न्यायालय में SAR अपील संख्या 1600 दायर किया। माननीय अपर समर्था रांची ने अपने आदेश दिनांक 26/6/96 द्वारा आपत्तिकर्ता के दावे को अपना पक्ष को देखने का अवसर देने का निर्देश दिया गया। आपत्तिकर्ता की गवाही कार्यालय में सुनवाई गए इनके अतिरिक्त विपक्षियों से सर्वानंद साहू, वसंत लाल, जगदीश लाल, उमा प्रसाद सिद्धांत, गिरिजा साहू, विवेकानंद, अखिलेश्वर महातो, मोहम्मद इब्राहिम मुंदा गवाही कराएगी। डॉक्टर के सिन्हा, श्रीमती बीना नारायण की ओर से हर तारीख लगातार रसीद नगर निगम दाखिल खारिज मुकदमा 100 श्रुतिपत्र नगर निगम का लगान रसीद इतना विवादित पट्टा संख्या इतना का विकसित इतना निबंधित पट्टा लगान रसीद छात्रवृत्ति किया गया। विपक्षी की ओर से भी रसीद।
Please let me know that what is the document on the basis of which you are claiming the property.
I am a subsequent purchaser. I claim
Purchaser.
Your Worship kindly takes the list of its privileges. So that is there is undisputedly the recorded tenant is however recorded. Now the claim of the other side, the applicant, is that however sold the land to them in the year 1940 through a registered sale. That's their case. Our case is that however subsequently surrendered that land. There is no document, no evidence, document to evidence that surrender to the landlord. But in 1943, by a Sada Hukumnama, the landlord, whose name is Sheikh Rahman Ali, he gave us the land to, on Chaparbandi land 2 minutes, my predecessor in interest. And thereafter, on the basis of Sada Hukumnama and followed by rent receipts minutes, we have all that. Now, Sheikh Rahman, he sold the land in question by a sale deed to the petitioner in the year 1979, 9/6/1979, after obtaining permission under the land ceiling. Urban land. Then I came in 1979, rent receipts were issued, rent receipts annexure 3 would show Chaparbandi rent. Then the SAR case was filed in 83 by Respondent Poriora, who is the wife of Bhava Rao's son.
Wife of?
Hariora, yes, Hariora. The father-in-law is Hariora Rao. Bhava Rao had sold it to Hariora Rao. I am his daughter-in-law of Hariora Rao. Sorry. Now, in that proceeding, first round there was no evidence there. In the second round, there is some evidence there. What we had led evidence is, in fact, we had also got the circle officer to come and depose to say that the land is recorded now nature is Chaparbandi. That evidence was also there. No contrary evidence was led by them to show that it retained its Rayati character. Plus, the municipal holding numbers also show holding will only come when there is a construction. Chaparbandi is nothing but when the land is not used for agricultural purpose but to use for residential purposes. That's
But for the Chaparbandi also creation, there is a particular cut-off date.
there is but there is no dispute regarding that this Chakrabandi procedure was not there. It is for them to challenge it. Because rent we have paid, and in cut-off date in our case, my predecessor itself, the initial settlement itself was in Chakrabandi, that by the ex-landlord. And rent was also fixed Chakrabandi. So that cut-off date we have is 1943, so far as this land is questioned. Now, the application, in that application I will show it to your lordship, where they have said that somewhere between 76 to 80, because Hariyar Rao was not in the right state of mind, they have been dispossessed. That
76 to 80.
80. That I will show you, that your lordship will find that word assertion.
And your sale deed is of the year 1980.
My sale deed is of the year 1979.
79.
Just for a moment, I'll just show that assertion.
And you were paying
I'm
rent?
still paying.
No, the property was mutated in your
Yes, my property is muted.
What
That
is
is
the
immediate.
earliest rent receipt you have
Yes, earliest rent receipt was
in your name?
here was annexure 3. This is in the name of Veena Rai, the wife in the first case, and this is from hers. DT.12.03.2026.
And this is 8180.
Because
It's actually
79
after that.
After that, actually correction slip was issued and then rent receipt. That correction. And my sale date in fact was 79 is June. So that 80 probably I filed a case in 78. Mutation case was 78 80 only. I filed it 3.
There was a title suit. also?
Yes, title suit was amongst 2 other people. I am not a party to the title suit. Where respondent 5 and 6. But now there is an intervention application which I was reading minutes in the original court's order. There is a reference to intervention by another person. There was an interstate dispute between them regarding title in which the respondent 5 had succeeded. But that is again behind my back. In fact, not even my vendor was also not a party. Now, interestingly, there is one aspect which you must know, and I will show the page number and therefore it will be easier for you to know. In that civil suit, of which they are talking about, they have filed a document along with the contract review. Kindly come to that contract review, that judgment. I just wanted, since Lordship wanted to know the civil suit. They have got the judgment at page 23. 557.
23 of the contract.
But I think it is in 6 counter.
Judgment head is a suit for delivery of cast possessions.
Yes.
Page number 26 in the contract.
Yes.
It covers both the properties.
Yes. They are covering more than this property.
Okay.
In fact, the suit was, the original application was against 6 people. We are only 2. The other people are not even challenged for some reason. Now, what I want your lordship to note from here is, kindly come to internal page number 4 of that judgment where it records the case of the plaintiff. Yes, kindly come to us.
The plaintiff here is the defendant, is the respondent in this case.
Respondent, yes, Vaishnav.
Vaishnav.
It is his case before the trial court. What I want your lordship to see is paragraph 4 where he says it states about his case. Now, paragraph 4, kindly just come to the middle, the word that is possession.
The proceeding was converted under section 145.
Yes, about proceeding and the learned magistrate without appreciating the facts and the circumstances of the case illegally and arbitrarily declared the possession of the defendants over the suit land under his order dated 23/11/1971. The defendant being involved by the said order wrongfully and forcefully disposes the plaintiff, now kindly disposes the plaintiff from the suit land 24/11. What I am trying to show is that in that suit his case was that he was disposed by someone else on 24/11/1971. Not that it makes much of a difference towards limitation, even if this is accepted. But this I am showing is inconsistent plea taken at different forums by the same person.
They did not leave any evidence.
The evidence they have not made any evidence. My only first point is not if you're is a legal issue which your options have decided lovely Munda, and I try to find out whether an appeal has been preferred or not. I don't think any appeal has been preferred. No appeal. Where? Lovely Munda a judgment. Now, Para 37 of Lovely Mundane, which is mirrored at page 20 of the judgment. Now, where Para 37 in the middle, it is important. It is important to note that the date of possession slash dispossession and also the mode of possession slash dispossession have important bearing in the matter. In this connection, the previous orders in SAR cases for restoration of land involved in this case, filed by the vendor of the applicant Arjun Munda and or predecessor in interest of the vendor against or in favor of the petitioner's predecessor in interest of the petitioners, and also execution of such orders, if any, are also required to be considered. Although in the initial application as produced by this court and also the relevant counsel for the parties, no specific statement has been made by Arjun Munda regarding the date and manner of disposition. But before the authorities, much was argued by both the parties, but no clear finding has been recorded with regard to the date and manner of possession / disposition for Arjun Munda from the dispute property. The records received from the office of the commissioner reveals that the records which have been submitted before this court by the respondent state were not produced for perusal of the consideration, as a result of which the commission in the order has straightaway reached at the conclusion after recording the argument of the respective parties without deliberating upon the points raised by the parties and without considering the elements decided by them in the revision petition, and also so and so. So what I am only trying to emphasize is your lordship's observations that date and mode and manner of disposition are relevant factors. Why it is
What
relevant?
is the finding of the commissioner with regard to limitation?
The
Has he recorded any findings?
revision of arguments?
Yes, revision.
Yes, fine. Kindly comes page 86. It's just a small order or side page, let me give it so that I don't miss it.
Page 86.
What that is in my letter was.
Abhi ek second. Yes, page 86.
Third, this revision petition is directed against also, you should ignore that. Second paragraph, intervener's case is Vishwama Prasad Singh management, kindly for a moment also skip that portion. Then this is my case, OP number 1's case, now kindly come from that. OP number 1 Madhava Rao in cases 157, 158 or 98 is also the petitioner of case number so and so. His case is that Kuwari Topo has filed restoration petition that the land concerned. The land concern was sold to Hariyo Rao, her father-in-law, Goa Rao. Hariyo Rao also died and his son Vajnath, being of weak mind as his wife, she is claiming the land as transferee. Since recorded Rayets were two brothers, Goa had no right to transfer alone. His brother Sanika died and his wife Budni and three sons Bula, Ramdan, Maldan. Bula died leaving behind Madhava Rao. Therefore, Madhava Rao is no stranger but rather is a direct descendant of the recorded tenant. Land should actually be restored to Madhava Rao, petitioner of so and so. There was a partition deed and Goa and Budni got half share of the land. Vajnath Rao has sold his share to Ashok Tokno on 31st of August 2001, and Kumari Tokno and Ashok Tokno are disposing of the land in connivance with each other. I am of the view that since petitioners and interveners are claiming the land on the basis of Sada Hukumnama, the petitioner of SAR case number 157, 158, and interveners never produced any surrender deed, even they have not disclosed date of surrender. Thus, the entire story of surrender and settlement is false and purported only to grab the land of the Rayas who are members of scheduled tribe. The claim of the land being Chaparbandi was also not proved by any document. There are CO reports, but he was not examined on more, and so his certificate is void ab initio. Intervener has purchased the land when the case was still sub judice in the courts. What prevented them from not appearing in the lower court? And they have come before the divisional court straight away. So the land should be restored to bona fide tenants. OP number 2, Kuwar Tokno claims that since her husband Bajnath was not capable, she was doing everything. Bajnath also died recently on so and so, leaving behind 3 sons. The verdict dated 21/6/17 in title suit number so and so, given by civil court regarding right title interest of the land on the basis of registered deed dated 9/12/1940 is in favor of Bajnath Rao, husband of Kuwar Rao. Thus, the disputed land is restored to OP number 2, Kuwar Tokno, order not prescribed. So this there is no discussion. Now my learned friends is right. We must also read that appellate court's order. Deputy Commissioner's order is at page 48. Now, if you notice, this is a lengthy order. Page 55 onwards, the findings are there of the Deputy Commissioner.
Yes, ongoing.
Ongoing suit. In lower court order, it appears that learned lower court, while passing the order dated 1/3/97, adduced evidence on behalf of objectors and opposite parties and heard both parties and also government people. The learned lower court has mentioned in his order that opposite party appellants before this court could not explain whether land in question has been surrendered or not. As such, Sada Hukumnama dated 14/3/1942 cannot be recognized when the lands have been transferred by registered deed number so and so dated 9/2/1940 by the recorded tenant to Harior Rao, father-in-law of respondent, and at that time permission of Deputy Commissioner was not necessary, and on the basis of the sale deed, rent receipt was issued to the father-in-law of the applicant respondent before the court. The claim of the applicant objected before lower court Madhav Rao as to the descendant of the recorded tenant has not been accepted by the competent court in title suit number so and so. The learned lower court has come to the conclusion the land has been purchased legally by the ancestors of respondent in the year 1940, and by fraudulent methods, the respondent has been dispossessed by taking advantage of the unsound mind of her husband during the period 1976 to 1980, and as such, considering the possession of the appellant over the land in question in contravention of section 46 of the CNT Act, the learned lower court passed the order of restoration of the land to the respondent worthy. The orders passed by the learned lower court in SAR case number so and so on 29/4/97 has no relevancy with the case, as the land involved is different to this case, and the order dated 29/4/97 is one of the later date with respect to the present judgment order dated 1/3/97, and the alleged no objection accorded under Urban Land Ceiling Act also has no relevance. Considering the above facts, circumstances in absence of a valid document regarding surrender of land in question by recorded tenant and also settlement of land through Sada Hukumnama with Chaparwandi rights dated 14/3/1942 by ex-landlord to Sheikh Rahman and subsequent transfer does not give right to consider on the point of time, but clearly contravenes the provisions of CNT Act, and also the verdict given as civil court regarding right time and interest on the basis of the registered deed dated so and so in favor of respondent quality. I do not find any reason to interfere with the order.
This authority has tried to decide the title suit.
That actually, as I said, the recorded tenant was one. Then they were trying to say that there were two brothers. One sold the land in 1940. Therefore, the other branch was claiming. That is a definite matter. Title suit decided in their favor, which is ex parte behind my back. I am not a party, not binding on me. But the main point is the date of dispossession, because that goes to the jurisdiction of the matter. Because I have also tried to demonstrate that the inconsistent plea taken by them in the civil suit, which is in their favor, 1971 I was dispossessed here, 1976 to 1980 I was dispossessed, therefore gives rise to a valid doubt in my mind that which was the actual date of dispossession, which has not been discussed by anyone. No court has actually gone into this question. My surrender may be wrong, but in any event, if a land of a tribal scheduled tribe has been transferred without following the first, it is inalienable. Whether there is a valid document or not, it's void. So therefore, my absence of the valid deed of surrender is also of no consequence.
What do you have to say?
Can I just point out one? Second point is with regard to Chaparabandi. I had produced two evidence according to one document and one oral. Kindly come to annexure 4. Page 30. This is after remand. This is the Halka Karamchari owners on being summoned appear before the court. Annexure 4 is
Yes.
This is Halka Karamchari Sadanand Sahu Pita Soranso पेशा हल्का कर्मचारी सदर अदालत में मोहर के आधार पर साहब के निर्देश पर on being summoned here appear and he proved what
This
he
is
proved.
just photocopy. This is just type copy. I don't even have a photocopy.
But that is there in the order itself. I can show from the order also. The order of the trial court, the original court, and what he had. That also not from the. I'll show it from the courts that this was that this evidence was there on the record. Just. There was this record regarding the record of right was produced by the Halka Karamchari. Only says the record of the Hatyan was produced and saying that there the nature of land is Chakrabandi rent is being paid.
7980 से छप्परबंदी दिया जाएगा.
उसके अगर उसके पहले भी है बट उस समय का वो
उसके पहले का क्या है?
उसके पहले का एनेक्शर 3 है रिविजनल सर्वे में भी है और एनेक्शर हाँ
Ambata.
हाँ अम्बाटा वो ओरिजिनल खतियान में है उसके 1943 का सर रेंट ओवर टैक्स ओवर 29 में लिखा हुआ है बट दैट्स अ सादा हुकुम. Annexure 2 is this again the सादा हुकुमनामा type copy. It shows that
29 का तो type copy.
Annexure 2 is there. सादा हुकुमनामा says चक्रबंदी मालगुजारी सालाना 15 रुपए मालगुजारी है.
This document you did not produce before the commission. This.
Yes, these are all produced before the authorities.
They say that this Sada Hukumnama was not produced.
No, they say it is a Sada Hukumnama, therefore not accepted. That get produced. Surrender has not been. The surrender of the tribal and to the Zamindar and then Zamindar settlement, they say means you have not shown the surrender.
Not any date having been served.
Now, page 52 minutes you will find, just for a moment.
Annexure 3 is.
Annexure page 52 is the appellate court's order.
Annexure 3 is what date?
Annexure 3 is 81-82 का rent हुआ था minutes. ये दिखा है आप. Your Lordship noted that यहाँ पे 81-82 का rent. Now, I just want your Lordship last year to come to page 52, just to show that Annexure 4, the evidence was there before all the authorities. Page 52, in the middle, your Lordship, where the stamp is there, the second stamp begins. Karamchari of Town Anchal.
52.
Page 52.
The Karamchari of
The Town Anchal brought register 2 and gave evidence in lower court and Chakrabandi entry along with mutation case were proved. So this is only that is the type of which that he brought the register to, which shows that.
In the suit, there was also a direction for restoration of possession.
Possession. Now that is a point that if we were in possession, the execution ought to have been effected through the court. There's no execution.
I do not know, but in the suit,
Yes, that was the prayer that I have been dispossessed.
yes.
Now please put me back in possession.
That's
So if this suit is of 77, the suit judgment is of minutes, the year. Just. Yes, the suit was decreed on 16th June 1977. That is before my purchase.
Yes.
When my predecessor interest was supposedly, so there is no execution which put them in possession because it can't be. He said now 76 to 80 he was of unsound mind. That period when his judgment is passed, he says he was on unsound mind.
When was the application filed? Application for
This
restoration.
is application for restoration. This was specific date is not there, but it is 83, 84. The case number is 83 of somewhere in the year 83.
83, 84. So your predecessor in interest was in possession of the suit property.
14/3/1943. According to us. And I came 9/6/1972.
And your predecessor in interest continuously paid the rent.
Yes, that is our case, but there is no documentary. But there was a correction.
Is there any, that is also not on record.
Correction slip, but we have mentioned about a proceeding that there was a correction slip proceeding which was initiated immediately after my mutation case.
Is there any rent receipt issued in the name of your predecessor in interest?
That reference is there in the trial court, but not in before this court. I'll show it from the orders. What to?
Because even if there is a Sada Hukumnama,
Yes, sir.
and if we have to acknowledge that, it has to be followed by
That is what 68 Patna says, followed by Rochester, that merely Sada Hukumnama has no value unless it is followed by rent receipts.
That's
In terms of 117 TPF, that is the only way you can prove your possession.
yes.
Nothing more, nothing less.
Is there any rent receipt?
The only document which otherwise is mirrored is this prior permission under the Urban Land Ceiling Act before the transfer to me. But Chaparbandi we have
Why
maintained
was it required, permission was required under urban
because
lands?
urban land ceiling problem was at that point of time the anyone who had a particular area, if I had a particular area, I had to take the
Excess
permission-
area.
excess area to show that it's not within that excess. I am not selling something which is prohibited, otherwise should have been seized by the government. I just checked mirror that anything on record to show is that valid question of your option that what is the proof that my predecessor interest had. I just showed. Did that am I not pretend?
हाँ बताइए. Same identical facts are there in both the cases.
Both see, it's a larger chunk of land.
Yes.
are concerning limitation is concerned. Section 71A itself.
Uh, 71A as such does not say 30 years or 40 years.
That is for purpose of compensation. Our provision 1. But for maintainability of the application and for limitation at any time, if the district attorney comes so, and that has been upheld by full bench of this court also. That for purpose of maintaining application under section 71A, limitation is no part. Only for because the provision says not.
So do you want to say that anybody can come at any time? Anybody can come at any time?
Purpose 71A.
Any
Anytime.
So there are so many judgments, Pandey, Oda,
That is starting of the language.
No, we have seen the language.
Yes.
Even this language has been interpreted by, sir, please.
30 years.
71A is a much contested section in Jharkhand, right? There are numerous judgments on this, irrespective of the fact that it can be taken care of at any time, the applicant can come at any time. But still there are judgments which says that 30 years or more than 30 years. It cannot be any time does not mean in perpetuity.
The original Acts of the section 7 law provided that if transferee has been 30 years from the date of transfer constructed any building or structure or such building or portion thereof, the Deputy Commissioner said if the transferor is not willing to pay the value of the same, order the transferee to remove the same within a period of 6 months from the date of the order. So this 30 years time lot is not for purpose of
आप सीटू साउ
application.
जजमेंट आप सीटू साउ प्लेस करिए ना, आप ये सेक्शन से मत प्लेस करिए. This particular provision was subject matter of consideration by Honorable Supreme Court in the case of सीटू साउ.
Yes.
Yes, where the court says that you cannot invoke 71A at any point of time. The court said that you cannot invoke at any point of time. At any time does not mean that you sleep throughout. And there the delay was 30 years. I think it was 30 years, 40 years. The court said that no, this is inordinate delay. Delay and latches. You see, there is no limitation as such, but delay and latches has been taken into consideration.
Can I say that the question of law, actually what the Supreme Court has also missed is by the Bihar Scheduled Area Regulation.
Even that has been taken into consideration.
No, but this amendment is limitation.
Yes, that has also been taken into consideration in the case of C2 Sound. And it has been referred to, but not specifically considered.
Yes.
But it has been referred to.
But
It
it
has
only
been
says in the matter of scheduled tribes, it is Article 65 of the Limitation Act. It will be replaced from 12 years to 30 years.
That's why that is adverse possession,
That's
primarily.
Absolutely. That is adverse possession.
That is adverse possession.
And C2 says unreasonable long period is
Yes.
not.
Yes. And C2 Sao has taken note of this.
It has-
Although it has not been
Not-
specifically
yes.
applied, but it has taken note of this amendment in the.
In the Act.
Yes.
Particularly in this case, specific case of applicant respondent is that in the year between 1976 to 1980, the 6 persons were the opposite party in
Did you lead any evidence? Your application is sufficient. Did you lead any evidence? Did you examine yourself? So,
but admitted
system, how is it admitted?
can you consider that under section 71 A law, Supreme Court has several occasions say that it is for protection of the scheduled tribe and liberal consideration has been taken in law against the person.
Liberal consideration does not mean.
Admittedly, the original Raya had sold the land in favor by registered sale deed in the year 1940 itself.
That's right.
Thereafter, neither original Raya nor landlord had any occasion to settle the land, whether by way of Saparabandi or by agricultural, that is material law. When original Raya has sold the land to father-in-law, the respondent law by registered sale deed, how do there are any occasion to surrender the land or any occasion for the landlord to issue any sada hukumnama in favor of anybody. So this aspect has been considered by all the court below law and said that in view of the registered sale deed in favor of father-in-law of the respondent law, the sada hukumnama without having any assertion of a surrender or any document of surrender is a fraudulent matter. And so far, on the basis of that sada hukumnama, if the revenue authority has issued any certificate that it is Saparabandi, that document is also a fraudulent matter. This court has on several occasions, several governments said only the assertion in Sada Hukumnama is not enough for proving that this property is Chaparbandi. It must have use of Chaparbandi, that means residential purpose. There is no evidence left by the party, by the petitioner, that there was any house constructed there. Whereas the document my friend has cited as an actual one, says that it is agricultural land. And thereafter, so after on the basis of the fraudulent document, Sada Hukumnama, if the revenue authority as a created a revenue local Chaparbandi or issue rent receipt as Chaparbandi, that is fraudulent manner. That has been considered by the Learned Deputy Commissioner and SI Court and Learned Commissioner Court. And this one they will put out in several
They are claiming the property by virtue of Hukumnama of 14/3/1943.
Yes.
So your sale deed is of 1940. Your possession stands recorded in the record of rights also.
Yes.
So your contention is when the property was already sold,
Right.
then under such circumstances there can be no question of any surrender
Or any
Hukumnama or any settlement. And the claim of the petitioner is on the basis of surrender and settlement and followed by a sale deed.
Absolutely. And the court will have that, neither find any document.
After the property was sold to you in the year 1940, do you have rent receipts?
I have got the rent sheet from the Jharkhand.
From whom?
Commissioner क्या?
Where is that? Is it on record?
जजमेंट पाया।
कहाँ जजमेंट में है कि आपके नाम से रेंट रिसीट?
का जजमेंट जो है उसको दाखिल किया गया था।
इसमें कहीं आया है that you were paying rent to the
That
state?
judgment has been produced before the court, and the court has seen that observation about issuance of rent receipt. उसके बाद जो है सो
Who is the defendant in the title suit? Who is the defendant in the title suit?
title suit में जो है one impersonating person claiming that he was the descendants of one Sanika Rao, descendant of the wife of Sanika, the brother of Goa. Fraudulently, and he got a degree of partition. And for that purpose, title suit was filed. And that degree was set aside, and the right title has been decided in favor of.
There is a direction to hand over possession to you.
वो अपने छोड़ दिया, इसीलिए कोर्ट से क्लाइंट पूछना नहीं कर पाए, वो अपने ही पोजीशन छोड़ दिए, उसके बाद हम पोजीशन में आए, वो बराव जो है, वो आया था यहाँ पर, इसके साथ ही जो रिट फाइल किया था, वो ना उसे पूरी पोजीशन विथड्रॉ कर लिया, और डिसमिस हो गया, किसने एक्सप्लोर हो गया, तो उसको सेट किए थे कि कॉन्फिडेंशियल मतलब लिटिगेशन बढ़े, इसलिए लोग सेट किए थे उसको, और इसमें particularly specific fact ये है he had sold the property in both cases. SP Narayan and Bina Narayan both had sold this property, and the purchasers were the intervener before the commissioner. But they have not made party in this case. So he had no interest in the property. And not the original application was against 6 persons, and against the original order only one person had filed appeal, and on that basis that was demanded. Thereafter only SP Narayan and Bina Narayan had challenged in appeal below, and other persons, that a common judgment for against all, they have neither made party in appeal nor in revision nor in this writ petition. So that order become final, And if this petition will allow to proceed, they will be
They are only concerned with they are only concerned with their property. They are not concerned with the properties of rest of them. You claim the entire chunk, right?
Yes.
And you made several parties who were in possession.
Ending on limitation and Chaparbandi.
No, if others they do not challenge, they will not get the benefit of any judgment, if any, passed in their favor. There is no question of a person who has not challenged the order. There is no question of.
One judgment of this court, Mr. Justice Kohli, that if all the parties, the revenue authorities, had not been made party in
The revenue authorities are party here.
No. Private party, revenue से में party. जो अपोजिट पार्टी था 6% था, तो उसमें जो है सिर्फ दो ही पार्टी जो है सो उस ऑर्डर को चैलेंज करके आ रहे हैं, और सब जो है सो चैलेंज नहीं किया ना, इनको उसको इन लोग पार्टी बनाए.
You see, you have distinct cause of action with respect to other parties, right? You have distinct cause of action with respect to other parties. They are not claiming through the petitioners. Are they claiming through the petitioners? No. Are they claiming through the petitioners?
No, against all 6 persons.
Against all distinct 6 persons, you filed an application, a common application for restoration.
Common reply भी था.
Common reply भी था, जो भी कुछ था, but you see, for different persons there will be a different calculation for limitation. We do not know. They are not interested in contesting the case.
76 80 का ही पीरियड का जो है सबका सेम डील था, और 1943 का ही हुकुमनामा के बेसिस पर जो है वो सेल डील करवाए थे. 1940 का हमारा रजिस्टर्ड सेल डील है, तो दैट विल बाइंड ऑल ऑफ देम. रजिस्टर्ड सेल डील जो यहाँ पर है वहाँ सारा हुकुमनामा सब्सिक्वेंट टू रजिस्टर्ड सेल डील is apparently fraudulent thing. So far concerning Chaparbandi is concerned. We alleging in Sara Hukumnama that is Chaparbandi, that is not sufficient. The court says that must have use of Chaparbandi. Chaparbandi means कि रेसिडेंशियल हाउस. छपरबंदी टैक्स होता है, जब घर रहेगा उस पर तब उस पर जो है छपरबंदी म्यूनिसिपैलिटी लगाता है. यहाँ पर रेवेन्यू अथॉरिटी को जो है उस लगाने का भी पावर भी नहीं है. लिखवा दिया है उसे ये छपरबंदी है, रहती लैंड में छपरबंदी करने का रेवेन्यू अथॉरिटी को पावर भी नहीं है. ऑल दीज आर फ्रॉडलेंट थिंग. ना तो कोई एविडेंस है कि वहाँ कोई घर बना है या कोई उसमें रह रहा है. इसीलिए नेक्स्ट प्रीवियस ओकेजन और नेक्स्ट में बहस हुआ था, तो कहते थे हम दिखाएंगे कि रिकॉर्ड ऑफ राइट टू मेक छपरबंदी है. उसको टाइम दिया गया था, दो बार टाइम मिला है, बट ही कुड नॉट प्रोड्यूस दैट बिकॉज देखिए एडमिटेडली चीज है लिखा हुआ है उसमें अम्बाटर लैंड है, एग्रीकल्चरल लैंड. इसको आज जो है सो हुकुमनामा के बेसिस पर जो है रेवेन्यू अथॉरिटी को मेल करके जो है रजिस्टर टू खुलवा लिए, उसमें एंट्री करवा दी छपरबंदी, उसे फिर करवा ली रसीद करवा दी. तो सो फ्रॉडलेंट थिंग हैज टू बी अपरेंट. फ्रॉडलेंट इज अपरेंट व्हेन दे आर रजिस्टर्ड सेल्टी बाय original region in favor of the father-in-law of the respondent. How does the occasion, what is the validity of that region or any landlord to surrender or issue any Sada Hukumna? That is a fraudulent thing. That aspect has been considered by all the revenue courts, including commissioner. In Pandavara case, Supreme Court categorically held that if any improvement has been made in the land, that cannot debar the jurisdiction of the court under section 71A in view of proviso of 71A. That is, I don't think permitted to no right case tribunal. There is no dispute that there has been improvement of the property rights to the one. We are aware the case we are transferring to our reached the law and taking recourse to fraudulent methods, tax property and makes improvement. So if that no, there is no improvement. Actually, in this case, no improvement. But if he had a late improvement, that not debar the authority for exercising power under section 71. And so far limitation is concerned, limitation specific finding on the court that 1976 से 80 के बीच में डिस्पोजेस किया गया है। टाइटल सूट में जो मांगे थे दूसरा के खिलाफ था, उसके बाद फिर हमको प्रोविजन आ गया था। लेकिन ये लोग जो हमको डिस्पोजेस किया है वो फ्रॉडुलेंट सेल डीड के बेसिस पर 76 से 80 के बीच में हुआ। अध्ययन आपने क्यों नो फाइल किया ऐसे आप इसका लिमिटेशन का सवाल है।
अच्छा, आप कुछ नोट बनाए हैं क्या?
हम फाइल किए थे 925 को फाइल किए थे।
रिस्पॉन्ड नंबर 5 ये आपका है। देखिए तो चेक कर रही है यही है।
Clarification,
Yes.
which is important is that I missed is the judgment of the 1972 suit was with respect to a different plot of land, same khata, 0.7 acre, 7 decimals only. So that we originally want to mark it. In the decree, you will find the schedule of the property. Decree is there after the judgment is at page 150. 157, 158. 158 you actually find the schedule.
Yes.
Plot number 2, khata number 77 is same. Plot number is 1099. My plot is 1123. And area is only 0.7 because it's 7 decimals of that. We are 1.22. This illustration was for 1.22 acres. We are concerned with 22 decimals only. 22 quarters.
I'm at page number 69. Sorry, 158. The schedule is Village Moravadi, PS Sadar, 192, District Ranchi.
Yes.
Khewat number 2, Khata number 77, plot number 1499.
1499. Mine is 1123. Our plot is 1123. And this is only 0.07 acres. The entire khata number 77 it was transferred apparently is more than 3 acres.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that both the cases are of identical nature and they arise out of the same proceedings. Same proceedings.
Yes.
In WPC number 332 of 2003, Dr. H.P. Narayan is the petitioner, and in the connected writ petition, being WPC number 557 of 2003, Srimati Veena Narayan is the petitioner.
Was the petitioner since this is HP Narayan as substitute?
Substitution why?
Okay, substitute.
He submits that upon death of Veena Narayan, the Dr. H.P. Narayan has been substituted
By the order dated 23rd January 2020.
by the order dated 23/1/2023. You have not carried out the necessary.
So this
Please do it.
I will do.
I'm not passing any order to that effect. Please do that. अच्छा लिख ही देते हैं. Apparently the petitioner was directed to carry out the necessary correction in the first title by deleting the name of the petitioner in WPC number 557 of 2003 and inserting the name of her husband, but the said amendment has not been carried out. Counsel for the petitioner undertakes to do the needful during the course of the day in reading. इसको कर लेना.
आगे कर.
The learned counsel submits that only 2 points are involved in the present case. A. The petition seeking restoration of land filed in the year 1983 was itself barred by limitation inasmuch as the applicant seeking restoration remained dispossessed of the land for more than 30 years. He has submitted that the predecessor in interest of the petitioners acquired the land through Sada Hukumnama dated 14/3/1943 and the petitioner acquired the same through registered sale deed in the year 1978 and ultimately mutation was carried out and Chapparabandi rent receipt was issued.
छप्परबंदी रेंट रिसीट तो दिख रहा है, रेंट रिसीट दिख रहा है, that is on record in the next case.
Rent receipt was issued indicating that it was a Chapparabandi rent receipt. Election 3 is Chapparabandi.
वो तो it is in my name. My predecessors rent receipts are there in the contract affidavit filed in the next case. वहाँ छप्परबंदी नहीं, but rent receipts दिख रहा है. I must be clear on that.
अब एक केस का दूसरे केस से कैसे मिक्स कर?
Same land.
सेम प्रॉपर्टी के नाम से तो कोई रेंट रिसीट नहीं है.
आपके नाम से रेंट रिसीट है, आपके प्रीडिसेसर के नाम से रेंट रिसीट है, ये कहाँ है? ऑर्डर में कहाँ है?
नहीं, डॉक्यूमेंट रिकॉर्ड पे ऑर्डर में
मतलब भाई नया डॉक्यूमेंट कुछ आप यहाँ ला के दे देंगे तो हाउ डू वी
एक्चुअली
एप्रिशिएट?
रिविजन में रिटर्न नोट्स के साथ फाइल हुआ था. To be very honest. But है डॉक्यूमेंट ठीक है. Let us not get into facts which are not there in the original records. I don't want to get into.
The learned counsel submits that the applicant remained dispossessed from the property and the application seeking restoration was filed stating that the owner of the property was of unsound mind during the period from 1976 to 1980, and taking advantage of this situation, the applicant was dispossessed.
Applicant and family.
Sorry?
Applicant and family members.
Applicant and her family members were dispossessed. The Learned Council has also submitted that the Chaprabandi rent receipt, that the rent receipt showing that it was Chaprabandi itself reveals that the property was Chaprabandi, and therefore Section 71 capital A of Chotanagpur Tenancy Act is not applicable to Chaprabandi land. The Learned Council has further submitted that these aspects of the matter have not been properly considered by the authorities, and therefore the impugned order ultimately upholding the order of restoration is fit to be set aside. He has also submitted list of dates and written notes of argument and has relied upon the following judgments. इसे paragraph number नहीं लिखी है, quotations में लिख दिए हैं.
She has extracted the judgments
Okay.
in the notes itself.
तो soft copy भी दे दीजिए.
ठीक.
The Learned Council appearing on behalf of the private respondent has opposed the prayer and has submitted that the private respondent is the descendant or nay, has purchased the property by virtue of a registered sale deed of the year 1940 and remained in possession.
Private respondent, original applicant, because there are other private respondents as well.
The private respondent, the original applicant. He has also submitted that since the property was already transferred by way of registered sale deed way back in 1940, there was no question of any surrender and settlement, any surrender of property and subsequent settlement, that too by Sada Hukumnama dated 14/3/1943. The Learned Council has also submitted that the vendor of the petitioner had no right, title, interest and possession over the property. And therefore, no rent receipt in the name of vendor of the petitioner was produced before the court, before the authorities. The Learned Council submits that there is no question of the petition being barred by limitation, inasmuch as the applicant was dispossessed during the period from, sometimes during the period from 1976 to 1980, applicant and his family members. We have submitted that there is no question of any Chapparbandi in agricultural land, and Chapparbandi essentially means a house property and non-agricultural land, and under such circumstances there is no question of issuance of rent receipt in connection with Chapparbandi property. He has also submitted that a specific order was passed by this court asking the petitioner to bring on record the record of rights showing that the property was Chaparbandi, but no such affidavit / document has been filed by the writ petitioner. He submits that merely because the revenue authority has stated that the property was Chaparbandi, the same has no bearing in the matter. The Learned Counsel has also submitted that under the provisions of Section 71 capital A of Totonaco Tenancy Act, no period of limitation as such has been provided, and the proviso to Section 71A provides that if the transferee has within 30 years from the date of transfer constructed any building or structure on such holding or portion thereof, the Deputy Commissioner shall, if the transferor is not willing to pay the value of the same, order the transferee to remove the same within a period of 6 months from the date of the order. The Learned Counsel has also submitted that it has further been provided that when the Deputy Commissioner is satisfied that the transferee had constructed a substantial structure or building before coming into force of Bihar Schedule Area Regulation 1969, he may, notwithstanding any other provision of the Act, validate such transfer, where the transferee either makes available to the transferor an alternative holding or portion thereof, as the case may be, or equivalent value, and pay adequate compensation. The Learned Counsel has submitted that there is no material on record to show that the property was no coded material on record to show that property was Chaparbandi, and the plea that the property was Chaparbandi has been rejected by the learned authority. We have submitted that there is no perversity in the impugned order, and therefore the same does not call for any interference. The private respondent representing the original applicant has also filed written notes of argument in this case and has relied upon the following judgments. इसको थोड़ा नोट कर लेंगे कौन से जजमेंट्स हैं इसके। आपके पास भी सॉफ्ट कॉपी है इसका? नहीं हो? अच्छा, we'll manage it. That's all. एक चीज और, the Learned Counsel 1992 Supreme Court, बताइए. He has also relied upon 1992 Supreme Court. 1992 Supreme Court. SCC. बताइए ना, ठीक से बताइए. Has also relied upon the judgment passed by the Honorable Supreme Court reported in the case of Pandey Oraon versus Ramchandra Sao. Para number? Para 6, 7 and 8. ये citation को डाउन से ले लीजिए.
और इसमें है कि जो बेंच को तस्वीर को सीधर बेचता है, लेकिन इसमें कहा गया कि there must have structure on the land for the purpose of a person using the same as residential, then Chaparbandi character can be proved.
By referring to the aforesaid judgment, the Learned Counsel submits that for the purposes of claiming Chaparbandi, the actual structure should be standing over the property which is used for residential purpose. He submits that there is no such, please hold. There is no such material on record to show that the property was chucked.
It is not in Pandera. He is referring to some single judge.
Pandora
Pandera does not say
improvement. But I don't like improvement. There is improvement.
that. For Chhaparvan there has to be existing structure is not in Pandera. That's what I'm saying. It is in
कौन
some
सा
other-
जजमेंट है सिंगल जज का जजमेंट हम नहीं देख सकते हैं
हाँ, देख सकते
हम
हैं।
तो कहीं का भी
Binding-
जजमेंट देखते हैं है तो दे दीजिए एक है कि दो है तीन एक ही जजमेंट बहुत है ना सिंगल जज का कौन सा आपको सबसे बेस्ट जो लगता है वो अच्छा दीजिए
संज्ञान साहब का है, कमिश्नर साहब का है।
अपने कोर्ट का होना चाहिए किसी भी जज का इससे कोई फर्क नहीं पड़ता The learned counsel has, for their future proposition, the learned counsel has relied upon the judgment passed, judgment reported in 1986 SCC Online Patna 153, then 1989 SCC Online Patna 250, and 2006 SCC Online JHAR 1199. Order reserved.
It is soft copy.
इनका तो सॉफ्ट कॉपी आ जाएगा इसको थोड़ा सा स्कैन कर लेना है इनका रिस्पोंडेंट स्टेट को कुछ बोलना है क्या The learned counsel for the state has supported has submitted that the improved order does not call for any defense under Article 226 of the Constitution.
Under heading for final disorder, item 3, WPC 5253 of 2006.
The written submissions. ये according to you, the petitioners and respondent first set had common ancestor. First set or second set? Second set. Who is that common ancestor? What is the name of that common ancestor? Page number? In the loudspeaker. Sorry, page number?
Page number 8 of the report.
No, I'm not able to get this. You say that the Mangru Manji ancestor of respondent first set, and Mangru Manji is also the ancestor of the petitioners.
Mangru Manji responded first.
Respondent first party. I want to know that you have stated that there was a common ancestor of the petitioners and the respondent second set. Who is that common ancestor? You have given the genealogy also here. I'm not finding this. I spent quite some time to find out that who is that common ancestor. Genealogical table is there at page number 8.
The land has been recorded in the name of Manager Kumar, son of Kali Kumar, and Sugar Kumar, son of Kailas.
That's right.
Although it's not mentioned in the genealogy table regarding Manager Kumar and Sugar Kumar.
Land is recorded in the name of Manager Kumar, son of late Kaila Kumar, and Jugal Kumar. But where do you get the common ancestor? You see, the Jamabandi number 41 of gangster settlement corresponding to Jamabandi number 46 of McPherson settlement will belong to the common ancestor of the petitioners and the respondent second set. Who is that common ancestor? Para number 6. Common ancestors कुछ मैचिंग नहीं दिख रहा है इसमें. Who is that common ancestor? कुछ imbued order से भी नहीं पता चला.
Myself will try to figure out that ancestral genealogical data.
क्योंकि आपका जो जीनोलॉजी है उसमें भी कहीं नहीं है इसे. It is not there at all. Respondent second set is descendants of Jugal Kumar, right? And respondent number 12 is Bechni Kumari, wife of Bonsi Kumar. And who is Bonsi Kumar? How is Bonsi Kumar related to Jugal Kumar? These facts are not clear from the records. How do we कि डिसमिस करने को तो 1 मिनट लगता है, अलाउ करने के लिए बहुत दिमाग लगाना पड़ता है. Only to that.
Let us assume that all the facts on a common background are being submitted by respondent to the jury for the sake of argument, though it will not be my submission. Even though that the jurisdictional error which has been committed by settlement officer. First is twofold submission. First is that whether he can set aside in a collateral proceedings that I have relied on our national judgment for that. And secondly, whether it can be set aside after a period of 1941, decree can be set aside in year 1940.
This is the only point.
This is the jurisdictional error, and it is a settled principle under Article 226 manual that jurisdictional error is to be looked into regarding
Nothing more.
the facts are.
So that much should be sufficient. So
That
far
is-
as you are concerned.
That is my submission. Facts थोड़ा सा
Okay, let us see the, if that be so, let us see the judgment statement. R. Ranjan. Place that judgment. I'll come to you after some time because he is limiting his arguments to that. We'll confine it to that. Yes, please.
Para 12 is relevant. Para 12 is relevant.
CPC did you read para 9.
The precise question that calls for determination in the above backdrop is whether High Court was right in directing the appellant to seek redressal in a suit having regard to provision of Order 23, Rule 3 and Rule 3 in CPC. Order 23, Rule 3 and Rule 3 in CPC may at this stage be extracted for execution. 3. Compromise of suit. Where it is proved to the satisfaction of the court that the suit has been adjusted wholly or in part by any lawful agreement or compromise in writing and signed by the parties, or where the defendants satisfy the plaintiff in respect of the whole or any part of the subject matter of the suit, the court shall order such agreement, compromise, or satisfaction to be recorded and shall pass a decree in accordance thereafter, so far it relates to the party to the suit. Whether or not the subject matter to the agreement, compromise, or satisfaction is the same as the subject matter of the suit, provided that where it is alleged by one party and denied by the other party that an adjustment or satisfaction has been arrived at the court shall decide the question, but no adjournment shall be granted for the purpose of deciding the question unless the court for a reason to be recorded thinks fit to grant such adjournment. Explanation. An agreement or compromise which is void or voidable under Indian Contract Act 1872 shall not be deemed to be lawful within the meaning of this code. It is manifest from the plain reading of above that in terms of the proviso to Order 23 Rule 3, where one party alleges and the other denies adjustment or satisfaction of any suit or lawful agreement or compromise in writing and signed by the parties, the court before whom such question is raised shall decide the same. What is important is that in terms of explanation to Order 23 Rule 3, the agreement or compromise shall not be deemed to be lawful within the meaning of the said rule if the same is void or voidable under the Indian Contract Act. It follows that every case where question arises whether or not there has been lawful agreement or compromise in writing and signed by the party, the question whether agreement or compromise is lawful has to be determined by the court concerned. What is lawful will in turn depend upon whether the allegation suggests any infirmity in the compromise and the degree that would make the same void or voidable under Contract Act. More importantly, Order 23 would be clearly bars a suit to set aside a decree on the ground that compromise on which the decree was based was not lawful. This implies that no sooner a question relating to lawfulness of the agreement or compromise is raised before the court that passed the decree on the basis of any such agreement or compromise, it is that court and that court alone who can examine and determine that question. The court cannot direct the parties to file a separate suit on the subject, for no such suit will lie in view of the provisions of Order 23 Rule 3A CPC. This is precisely what has happened in the case at hand. When the appellant filed post number 5326 of 2005 to challenge the validity of compromise decree, the court before whom the suit came to be rejected came up rejected. The claim under Order 7 Rule 11 on the application made by the respondent holding that the suit was brought by the provision of Order 23 Rule 3 CPC. Having thus brought the claim rejected, the defendants could hardly be heard to argue that the plaintiff ought to pursue his remedy against the compromise decree in pursuance of post number 5326 of 2005, and if the claim in the suit has been rejected, to pursue his remedy against such rejection before higher court. The upshot of our discussion question is that High Court fell in a palpable error in directing the plaintiff to take a recourse to the remedy by way of a separate suit. The High Court in the process remained oblivious of the provision of Order 23 Rule 3 and 3 ACPC. Also ordered also orders passed by the city civil court rejecting the plaint in which the trial court had not only placed reliance upon Order 23 Rule 3 but has also the decision of the court in Pushpa Devi case holding that a separate suit was not maintainable and that the only remedy available to the aggrieved party was to approach the court which has passed the compromise decree. The following passage from the decision of Pushpa Devi case in this was that therefore the only remedy is available to the party to a consent decree. To avoid such consent decree is to approach the court which recorded the compromise and made the decree.
The date of compromise is
Date of compromise is
5 to 1940.
Decree has been passed in 28/8/1940.
28/8/1940.
Decree has been passed in
This is the decree. Now, in this decree, Mayang Laik, Makhan Laik and others, and Mangru Manji were the parties. So, Makhan Laik is being represented by the petitioners. Makhan Laik. Just a minute. They are all descendants of Makhan Laik. All the petitioners.
Petitioner 1, 2, 3 and 5 and this one, petitioner number 4 is also.
No, you see, as per the genealogy, Makhan Laik, it is Makhan Laik and others. Okay, so petitioners are the descendants of Makhan Laiks and others. Right? And Mangru Manji. Mangru Manji is respondent first set.
Respondent first set, sir.
The only defendant was Mangru Manji.
Manju Manji and Junda Manji was also respondent.
Was also the defendant.
My lord, it has been recorded in the order.
Mangru Manji and
Junda Manji.
Dhuna, Dhuna.
Junda.
And his brother Namani, at age 29.
Dhuna.
Yes, sir.
Were defendants. So according to you, this compromise was binding on them and no pronouncement could have been made so far as this particular compromise is concerned.
My lord.
Right?
And this, after this judgment, the only court which was competent was the deputy collector where this compromise has been set. Who could have set aside if there was any fraud or collusion.
No, even in case of fraud or collusion, the same court will set it
My
aside.
lord, that because deputy collector has only passed the decree.
Okay, this decree was passed by the deputy collector.
Deputy
That is
collector to Junda.
Okay. All right. On the day the compromise was passed, the compromise decree was passed, was the settlement in favor of the petitioners?
Our convention may not, maybe this is actual matter. Our convention that we have been in the possession of plot number 1649. But it has been submitted from here that the entire plot 1641 has been settled in favor of Mandu Manji. Yes, 1860.
No. When was it settled in favor of Mangu Manji? The settlement was cancelled, no? The settlement stood cancelled.
It was settled, my lord. Thereafter, a decree, compromise decree has been passed. Subsequently, in settlement proceedings before settlement officer, they have been who have been settled, Juna Manji, and they have been evicted. And
Subsequently, it is after the compromise.
after compromise in the year 84, before settlement, before 100 years. RE case number 59 of 84.
So in this particular proceeding, the settlement authority found that the petitioners were in possession of portion of this plot number 1861. And then the respondent first party who were found in possession of another portion of 1861, they were directed to be evicted. Okay. Alright, so far as you are concerned, you were not directed to be evicted.
We have been settled the 1861. We have been given.
Okay. This order was challenged
This order was challenged subsequently
by respondent first set.
respondent first set in MA number.
So respondent first set is concerned only with portion of A1861 and not the entire area which were found in your possession, isn't it? So the appellate authority restored the possession of respondent first set over the entire property by asking eviction of the petitioner as well as respondent second set. Correct? Against this, the revision was also filed and the revision was dismissed. You are only concerned with the property which you say is covered by 1861B. You are not concerned with A at all. And this property covered by 1861B is the property which was allocated to you in the compromise. Yes, what do you have to say to this?
The date of the settlement of rate is 5/2/1948.
And sister of the respondents as Rayats.
Yes, we are the liars, your lordship. Respondent first said we are the liars. The settlement is in our favor. Your lordship in 1940, I will just come to the timelines briefly, your lordship. Your lordship, that land.
Respondent first said, are they party in the compromise?
That's what it records in the subsequent order, because your lordship, they have not produced a compromise decree, not produced a title suit decree. Nowhere it's in the record. They have not even annexed in the date also.
But the party position is there.
Your lordship, that even the party position, your lordship, see in the S order, the S order, page 18, your lordship, the party is only Madhu Kumar who said Judeswar liar. There is no respondent second set there. Your lordship, see page 18. That's what they that subsequently SO notes this, that the second party in whose favor you have granted them the possession of it are not even party to the proceeding. Subsequently, it's noted, your lordship, in the SO. The SO order, your lordship, notes nothing. They just say there is a compromise decree and they granted. The evictors granted them that part of the possession and grant third parties of possession. Evictors.
Okay, let us see your dates first.
Yes.
This is eviction alienation suit was filed.
Yes, your lordship.
LGO court ordered eviction of both alienor and alienee. Petitioners are claiming through the alienee. Okay, entire plot settled in favor of respondent rider. Respondent first set, second set.
First.
Can I write first set?
Yes.
Respondent first set. When title suit was filed, we cannot say collusive.
Yes. Yes.
Okay. With respect to 3 bigha 7 katthas, this particular property is A or B?
Lordship, since in records there is no description, the only record is found in the impugned order.
That's
From
it.
B, and so it's that what they are saying, it seems to be B, but there is nothing to
Okay, let us take it, it is B,
Yes.
because you have not also filed any counter affidavit. 1861 capital B. Right? He is concerned only with B. Then Assistant Settlement Officer passed order in favor of the petitioners.
We may.
Okay. These are the other judgments we are relying upon. Are this 1415 SCC 471 we have seen?
Yes, Your Lordship.
You want to say anything
Yes,
more
Your
on
Lordship.
that?
Yes, on that, I think that this judgment is not applicable in the facts of the case. Your Lordship. One is that SVT is a special law that regulates how the entire proceeding has to be conducted in the Santhal Pargana. That's the governing law in this case. And secondly, Your Lordship, even taking our Ranjana case, I was submitting, Your Lordship, I have not instituted these proceedings, the compromise decree, the challenge to the compromise decree, this initiation of this fresh set of proceedings 1984 is not by me, it's by them. So and that's the institution. I have no occasion to challenge it. I have a right, and my claim is that I had a possession of the same one. That's the claim. I have a claim. I have the royalty settlement in 1940.
No, I don't get it. Which institution? The title suit or the present proceedings?
Your Lordship, the present proceedings.
The present proceedings have been initiated at whose instance?
They are on the basis of that decree, Your Lordship, in 1940, they asked for an action.
It's defendant second party. Madhu Kumar is defendant second party.
At the instance of the petitioners?
No, defendant second party. The respondent second party. Madhu Kumar. Judeswar liar.
respondent second party had instituted the present proceedings.
So, in the case of the Madhu, who are the descendants of the descendant of
I just want to know the present proceedings was initiated at the instance of the petitioners or the respondent second party or the respondent first party.
respondents.
On the Your Lordship, can we come to the judgments or judgments that have to Your Lordship has seen R. Ranjana, I will come to Gurilal Jain, Your Lordship.
Yes. I think I have a copy of that. I've got Gurilal. I've got Gurilal.
Your Lordship, this is full bench or full court order, Your Lordship, and how they have analyzed this. So, Your Lordship, the SPT has to be seen in its full background. It comes from its whole history from Santhal revolt in 1852, subsequently the 1872 regulation, and now after the 1872 regulation is passed, Your Lordship, they come up with, they record the riots, and the general principle is that's non-transferable unless until it's permitted by the revenue authorities under the scheme of the Act. That's the general principle. Now, Your Lordship, and in Gurilal Jain, Your Lordship, you kindly see para 7, Your Lordship. 7. The lands of the riots being inalienable, dubious margins adopted ingenious devices to grab. Your Lordship, it's a general motion of the Yes, Lordship. Kindly see para 14. That's right. After the preparation of the records of rights was completed in the 1908 regulation, Your Lordship. Section 27 is the predecessor of Section 20 of the present Act 1949 Act. Your Lordship, it prohibiting transfers by riots of their royalty holdings. Section 27 is there in court, I'm not reading it. Then it succeeded in 1949 by when the Act comes into place. Section 20 is replaced by Section 20, Your Lordship. Your Lordship, may kindly see what Section 26.
It is not alienable.
It's not. It's not inalienable, Your Lordship. The para 17 is the observation, Your Lordship. A review of the aforesaid enactments will show that there was no general incidence of transferability of royalty holdings in the district of Santhal Parganas. The Santhal Parganas Act of 1855 reconstituted the district with the old laws. Your Lordship, old laws and regulations applicable to a limited extent, none of which made royalty holdings that transferable. Again, Your Lordship, for the whole plot, I am the royalty landholder. Your Lordship, it's one. In regulation of Regulation 3 of 1872 original, Section 26 made provisions for dealing with the improper ouster from the land, and Section 27 prohibited transfer, Your Lordship. And Your Lordship, in this part, that transfer and subsequently, Your Lordship, they come up with that in this Act they have incorporated that fraudulent transfers includes collective suits. It's in that even you can't defeat a statute by way of collusive suits or any sort of compromise, Your Lordship. That second, and Your Lordship, this power of revenue authorities is either by way of application or also sumo, that they can revert back the land back to the royalty landholders, and the principle of limitation. Your Lordship, that one of the arguments was that the principle of limitation. Your Lordship, may kindly see para 32 onwards.
The adverse possession will still apply.
No, Your Lordship, in this adverse possession will also not apply.
12 years prior to the coming into force of 1949.
Yes, Your Lordship, that's not the case.
That's
That's factually not the case, Your Lordship. And the SO order notes this. That's not the case. They look into this matter because, Your Lordship, the first order, SO order, notes nothing. It has no details of anything. SO order notes this, that the by adverse quotation title cannot be claimed. And Your Lordship, subsequently on the Your Lordship may just the conclusion is on para 53. If I'm not wrong. The conclusion is on para 53. Para 56, Your Lordship. From the aforesaid discussions, I have arrived at the following conclusions: that there is no incidence of transferability of royalty holdings in Sathar Pragnas, and the subsequent observations are concerning regards the bias what was in the challenge in the instance. Coming to the next challenge, Your Lordship. Ram Narayan Shah versus State of Bengal. Your Lordship.
It's there with me.
Lordship, may kindly see para 8, Your Lordship.
Yes.
Para 6, Your Lordship. Para 6, after tax, and this amendment is 1922 amendment, Your Lordship. After the expression fraudulent method in the aforesaid clause, the following has been added by amendment by Bihar Regulation 1 of 1970. Fraudulent method will include decree obtained in suits by fraud or collusion. This amendment has been made for peace and good of the government in the area as the preamble of the regulation published. Para 8 is important. Subsection 5 of section 20 of the Act, as substituted by Bihar Regulation 1 of 1969, gave wide powers to the revenue authorities to annul any transfer of land against special act belonging to a Rayat who is a member of the scheduled tribe, as mentioned above, in contravention of the subsection 1 and 2 or by any fraudulent method. Your Lordship, along with section 20, Your Lordship, section 42 and section 69 also are of concern. The amendment brought in by the Bihar Regulation 1 of 1972 by adding after any fraudulent method the expression including decrees obtained by suit in suit. Yes. And the 9th paragraph, 8th paragraph. Next.
Yes, I've read.
The last judgment, Your Lordship, on this is Raja Miya, Your Lordship.
Raja Miya. I don't have that.
1986, SCC 9, SC Patna 120. Your Lordship, I have in the notes, Your Lordship, para 2 is the question of law, that is there, para 2. And I will come to para 4, if that same question of law is concerning compromise degree, Your Lordship. I will come to the observation, Your Lordship.
In this particular case, the compromise decree is by the deputy commissioner.
But the principle remains the same.
Yes.
Your Lordship.
Which paragraph are you referring to?
I am relying on paragraph 14, 24, 25 and 26. Paragraph 27, Your Lordship, is that?
Yes.
It is well said that a judgment decree in a suit is binding upon the parties to the litigation. But the same cannot be binding on a person who is not a party to the suit. In TS number 4 of 64, the parties were only plaintiffs and defendant number 3.
Why are you not party to the suit?
Your Lordship, they have in the act, from the records, my ancestors were party, at least from the, but Your Lordship, they have not.
That's right. They're
Yes,
not reduced.
that's right.
But you were party to the suit.
Your Lordship. Your Lordship, they are not the language of section 20. I am reading from the bottom. Your Lordship. The language of section 27(1) of the regulation is clearly and ambiguous. It prohibits any transfer of a holding by a writer, either by simply. Your Lordship, to sum it up, Your Lordship. Your Lordship, I am under the SPT Act, Your Lordship, under section 20, I am a writing holder. There is a decree and I in favor of the compromise collusive decree, Your Lordship. It's a collusive decree. And in the SO order, Your Lordship, in the 2 revenue order, it notes that how it was a collusive decree. and then you achieve it. And by way of that, they tried to obtain that what they couldn't obtain in the first place before this eviction alienation case. That's what they are trying to defeat the mandate of the statute, Your Lordship, by this. Secondly, Your Lordship, that is, as is noted in the judgments, the revenue authorities do have jurisdiction to take handle this under the SPT, Your Lordship.
Just one redundant point. On that second term, you convert the sacrosanct nature of the SPT and declare as fraud and collusion petty totally wrong. But who will hold that? And when he will hold that? Who is the competent authority and what is the time limit for
Your Lordship,
setting aside?
that doesn't matter, Your Lordship, in this matter.
Heard the learned counsels. Are you for the state?
Your Lordship,
Heard the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that the core question involved in this case is whether the compromise decree dated 28/8/1940 passed in title suit number 8 of 1940 within bracket Markhan, Layak and others versus Mangu Manji and Guna Manji instituted before the court of Deputy Collector to Tumka and was decided in favor of ancestors of the plaintiff of the petitioners could be set aside and held to be collusive in subsequent proceedings of the year 1984. The present proceedings arises out of the proceedings of the year 1984. The learned counsel has placed paragraph 9 and 10 of the aforesaid judgment and has submitted that the compromise itself is an agreement, and once the compromise decree is passed, any other court or the party cannot question the compromise. That too after a long lapse of time. The learned counsel for the private respondent, आप ही है ना respondent of the story. The respondent has opposed the prayer and has submitted that the present proceedings are guided by the Special Act of Santhal Pargana Tenancy Act, which was earlier guided by the regulation of 1872 and subsequently guided by the provisions of Santhal Pargana Tenancy within bracket supplementary provisions bracket close Act 1949. And he submits that the defendant first set were the rayats of the property, and the entire property under Santhal Pargana is not alienable as per the statute. He has also referred to the judgment passed by a judgment reported in 1972 SCC Online Patna 116 Lauridal Jain versus Subdivisional Officer Jamtada, and has submitted that the fact that the property is not alienable is apparent from the summary of the judgment as has been mentioned in paragraph 56 of the judgment. The learned counsel submits that once the property is not transferable and not alienable, even through compromise, it cannot be transferred. Such compromise is against the statute, and therefore such transfers through compromise cannot be recognized under law. He has then referred to the judgment passed by judgment reported in 1975 SCC Online Patna 14 and has referred to paragraph 6 of the judgment to submit that the fraudulent method has been included by way of amendment by Bihar Regulation 1 of 1972 so as to include decree obtained in suits by fraud or collusion. The Learned Counsel has referred to paragraph 8 of the said judgment to submit that the compromise decree itself was collusive and against the statute, and therefore the transfer was being in contravention of the act. It was a fraud on court and also the fraud on the statute, and therefore such compromise is null and void.
One additional submission, Your Lordship, that revenue authorities can look into the nature of the decree.
The Learned Counsel has also submitted that the revenue authorities have the jurisdiction to look into the nature of transaction. He has then relied upon the judgment passed by judgment reported in 1986, SCC Online, Patna 125, within bracket Raja Mia versus Puran Mia, and has submitted that and has referred to paragraph 27 to submit that a judgment/decree in a suit to submit that section 27 within bracket 1 of the regulation prohibits transfer of a holding by a rayat either by sale, gift, mortgage or lease or by any other contract or agreement, and the compromise decree is nothing but a contract between the parties. This particular aspect that a compromise, which is the fraudulent method, right, that has been introduced in the year 1972.
Included expressly, Your Lordship, but in the 1972 body, Your Lordship, is the same principle that they rely on. Even the legislative incorporation comes later, and that's what they notes in Ram Ranans also. That even the
The Learned Counsel has also submitted that though the decree obtained in suit by the fraudulent method has been included by way of amendment in 1972, but the principle that the property was inalienable has already been considered and held by the court way back in the judgment of Horilal.
That the fraudulent method, the definition even earlier includes collusivity. That's the para 8 of the Ram Ranans. That it's explicitly said that Horilal says this para 8, which is very distinct.
The Learned Counsel has also referred to paragraph 8 of the judgment in the case of Ram Narayan Shah to submit that the expression any fraudulent method is wide enough to include a collusive compromise decree. Right? Concluded?